Your Honor, I think we're going to have to address something with the court.
All right. Ladies and gentlemen, I am going to ask you to go into the jury room. Please don't discuss the case. We'll be with you shortly. Thank you. Y'all may be seated. Thank you. All right, go ahead.
Thank you, Your Honor. This goes back to some pretrial rulings by the court based on the court's ruling in the defense's proffer that pursuant to the state's Saudi motion that Mr. Melton would be the only alternative suspect raised by the defense. The reports, beginning with State's Exhibit 136, makes reference to an individual as a suspect who is neither Mr. Faust or Mr. Melton, and so the state would seek to redact that pursuant to the court's order. It's not relevant, and under 403 would be confusing to the jury. As it relates to State's 137, same thing. There's an individual listed as a suspect who is not one of the noticed individuals from the court's ruling on Saudi motion. 403, again, it would be excluded. I don't know that the state is going to get into, 138, yes, again, same individual's name needs to be redacted in the suspect line. As it relates to 139 and 140, Judge, there are a number of individuals' names on here that kind of fall into that same category I was speaking of previously. They are not Mr. Melton or Mr. Faust, and thus their names need to be redacted pursuant to the court's ruling because it would be confusing the jury under 403. So that would be the state's position, and I understand after discussing that with Mr. Faust, the defense is not in agreement as to that.
All right, thank you. Mr. Cruz, anything, sir?
Yes, ma'am.
All right.
A big portion of this case is the police's investigation and the way that investigation was conducted. Our position would be that other suspects that were looked at should be considered by the jury as opposed to making this case solely about Mr. Melton and Mr. Faust. As I stated in my opening, Your Honor, the jury's job isn't to determine whether or not Mr. Melton committed this crime. The jury's determination is to determine whether or not the state has presented enough evidence that Mr. Faust is the person that committed this crime. I do believe that in regards to the 401 objection, it is relevant. Law enforcement looked at other individuals. I believe in the reports, since I'm making the argument, they look at other individuals, but they don't have their, in this particular case, hair fibers, because it's hair, their hair, because these are hair tests. They have these individuals listed as the suspect, but they don't have any of their biological material. So it is relevant. I don't think it'll confuse the jury because, again, as I explained to the court, you have this person listed as a suspect, but in the report you don't have this individual's biological materials. So I would ask the Honorable Court to allow or restrict the state from restricting that individual's name off of the testing form, Your Honor.
Thank you. Anything further? Mr. Yalman-Chile, it's your motion.
I think the law stands for a contrary proposition, which I argued to the court.
All right, thank you. So, Mr. Cruz, your argument is in direct violation and contradiction to all of the orders that have been entered in this case. And I've said many times, and I will say it again today, that the defense had the responsibility, if it chose to enumerate other possible suspects, that not only did they have to, by law, provide the proper notice to the state that they were going to seek to introduce evidence as to other persons, but also a hearing needed to be scheduled pursuant to that notice. That notice is in the form of a motion. And we've talked about this many times. That has not been done by the defense, with the exception of Mr. Melton. And we had that hearing. And that evidence that both parties sought to admit with regard to Mr. Melton was agreed by the parties and accepted by the court that that would be admissible. I mean, not all of it, but just in general. But any other mention of any other suspects or things of that nature were prohibited based on the rulings by this court in several hearing days that we have had. And so I say that again to say that because of those rulings and because of the legal procedure that was not enlisted by the defense to get the proper permission to be able to talk about other possible suspects, it is prohibited. It is also not relevant based on the prior rulings. I agree with the state that under 403, confusion of the issues would be paramount in this moment. And so I'm going to order the state to redact those particular exhibits. I think they're 136, 137, 138, 139, and 140. Am I right about that?
Yes, Your Honor.
All right. I'm going to order the state to redact those exhibits, as we previously discussed, with regard to those rulings. I mean, I think that's, we've kind of gone over this.
May I respond, Your Honor? I may
You
have
may.
been heard. And I believe I may have explained it wrong. I am not saying that we want to say that this third person did anything. We're saying that it's relevant because it goes to law enforcement's investigation. And please forgive me for not, I probably didn't state that the first time. But they're saying, hey, this person was a suspect. However, the test is biological testing. The relevance for us is we're showing law enforcement said this person is a suspect, not because we're saying they committed the crime. We're saying look at the work they did. Person A is a suspect, but they don't have any of person A's biological material. And please forgive me if I misstated that the first time.
Well, I did actually understand this part of your argument.
Understood.
I did. And with regard to the comments you're making about the police work and how they conducted it, I'm not making a finding about that issue. But my ruling stands.
Yes, ma'am.
Because the defense has failed to provide the proper motion and notice that the law requires in order for the court to then make a determination as to even whether that evidence should be admitted. And so because of that, regardless of the reason that the defense or any party wants to introduce that evidence, it is prohibited.
Yes, ma'am.
All right, thank you.
Thank you.
How much time do you need, Mr. Yelman-Chile?
Just a couple of minutes,
All right.
Judge, and then I'll hand it to Mr. Cruz
Okay.
to make sure he has no objection as to form.
All right.
I understand he objects in general.
Okay.
And then one request I would make of the court is, we can redact it for today with a Sharpie. We also have the ability, though, to black it out digitally and then reprint the report with that blackout. And so at the appropriate time, I'd ask to, I guess, submit an alternative redacted version of the exact same report. Obviously, it's just a digital file at that time.
All right. I guess my question for the redaction process is, do you need to make a copy of that exhibit and then do it, or?
I think it's fine.
All right, I'll just leave that to you. We
Thank
just
you.
need to make the record clear. All right,
Yes.
we will take a 10-minute recess. I'll be back on the bench in 10 minutes. Thank you. All right, we are back on the record. Has the state finished the redaction?
We have, Your Honor, there may be a separate issue that we need to address with the court, though.
Okay.
And I haven't had a chance to talk with Mr. Cruz about it. It just came to our attention. But can we do that initially off the record or in chambers to discuss how the court wants to handle it?
Yes.
Okay.
We can do it in chambers if you want to do that. Let me see y'all at the bench just for a minute.
Hooked together with an optic bridge so that you can view the internal characteristics. Let me just get my stuff out of here.
Please be seated. Mr. Yalamachili,
Thank you, Your Honor. State calls Larry Peterson.
could you get Larry Peterson? Thank you.
Sir, if you would raise your right hand, do you swear or affirm the testimony you'll give to the jury today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please state and spell your name for the record.
Larry Keith Peterson, LarryKeithPeterson.
And, sir, are you currently employed in a full-time capacity?
I am not. I'm retired.
All right. And when's the last time that you worked in a full-time capacity?
I was retired from the GBI Crime Laboratory in 2008. So I was employed there from 1978 to 2008. In 2008, I was employed by the U.S. Army Criminal Investigations Laboratory until I retired from there in 2017.
Okay. And going back to before your employment, what type of educational background do you have?
Yes, I have a Bachelor of Science in Forensic Science from the University of Central Florida.
And what was your first job after college?
Was employment at the GBI Crime Laboratory.
Okay. And so between the GBI and the United States Army, how long did you work in forensic sciences?
That would be almost 40 years.
And as it relates to, we talked about your educational background prior to starting work at the GBI. What type of training did you receive when you went to the GBI?
Right. So scientists at the GBI trained me in various aspects of trace evidence analysis. During my employment, there was also attendance to seminars and classes on the evaluation of trace evidence, including professional organizations and, personal relationships with other scientists.
Do you have any professional affiliations from your time working in forensic sciences?
Yes, I was currently in emeritus status with the American Board of Criminalistics, also American status with the American Society of Trace Evidence Examiners. I'm a retired member of the American Academy of Forensic Sciences and retired and past president of the Southern Association of Forensic Scientists.
And as it relates to the Southern Association of Forensic Scientists, did you ever serve as president of that organization?
Yes, I did.
All right. Have you ever had any publications regarding forensic sciences?
Yes, I've published several articles on trace analysis.
And have you ever been recognized for your work in forensic sciences with any types of awards?
Yes.
Your last title at the GBI or job responsibilities, what was that?
The title was a microanalyst, generally a person who is responsible for evaluating what's generally considered microscopic or very small amounts of material.
Okay. Did you have any leadership roles as it related to your time in the trace evidence section?
For approximately the last 9 years, I was deployed with the GBI. I was the trace evidence not supervisor, but I was supervising the competency as technical leader of the section.
And you said supervising the competency as technical leader of this section. Can you elaborate a little bit on what that means?
Generally, it's the person who is responsible for reviewing and generating revised protocols and procedures, and also oversees proficiency testing.
Okay. And have you ever testified as an expert in any fields?
Yes, I've testified on over 400 trials in various aspects of trace evidence.
Okay. And as it relates to various aspects of trace evidence, have you testified as an expert in the field of human hair analysis?
Yes.
Okay. And have you testified in the states, in the courts of the state of Georgia?
Yes, state courts as well as federal and military as well.
And Your Honor, at this time, I would move to tender Mr. Peterson as an expert in human hair analysis.
All right, any objection from the defense?
No, ma'am.
This witness is qualified or tendered as an expert in human hair analysis. You may proceed.
Thank you, Judge. Mr. Peterson, next, I would like to talk to you a little bit about human hair analysis, and I would like to start with the science behind human hair analysis. Do human hairs contain any unique or variable characteristics?
Right. So the science of comparing hair is that a recognition that hair contains several basic parts. So there's a cuticle outer structure of a hair. There is the basic protein, the main portion of the hair called the cortex. Some hairs contain what's called a medullary structure, a medulla, which is kind of an air-filled tubular structure that can appear down in the center of some people's hair. So based on, and the cortex of the hair contains the pigment granules, which gives the hair its color. So there's an evaluation microscopically of all of these features, both from a gross microscopic or a low power magnification view, as well as a detailed detailed microscopic comparison with a question and a known hair, in an attempt to determine if there's an association between those two samples.
And so as it relates to the variable characteristics that hairs can have, are there certain characteristics that have a lower rate of occurrence and will be more unique as opposed to other characteristics that have a higher rate of occurrence and less unique?
Right. Some hairs possess fewer characteristics than others just based on the amount of features that are available in the hair. For example, a very fine diameter blonde hair would have fewer characteristics to observe than a larger, more heavily pigmented hair.
Okay. And as it relates to hairs, an individual strand of hair, is that uniform from one side of the hair to the other side of the hair?
No. In the examination process, it's understood that the root end, or what we call the proximal end of the hair, would have different characteristics as you progress along the length of the hair towards the distal or upper end. It's just a natural progression over time, how hair changes as it grows.
And now I want to shift with you to the process of conducting a hair analysis. Is there a scientifically accepted process for conducting that analysis?
Right. So as I described, so in the process of procedure, you would start with the mounting or the collection of the hair, whether it was submitted as a collected hair or it could have been submitted as an item of clothing or something else. And then hairs would be recovered in the laboratory. However that process happened, the hairs would be mounted on a glass microscope slide in a mounting media to allow for its closer examination, which would begin with the stereo or low power magnification, around 10 to 40 magnification. In that classification process, we can look at the overall length and color, the shape of the hair, give some idea of maybe some racial origin information, certainly body area origin as well, and can be the first step in the association or the elimination of a question hair from a known hair sample. So a question hair would be one of unknown origin. It's a hair recovered from a crime scene or something of unknown origin. And we would have known hairs, a collection of hairs that represent the known hair of a particular individual. That range of knowns would be fairly tight to one another, but even hairs collected from a single individual is not going to be identical to one another, but they're going to be very, very close in characteristics compared to known samples from other individuals. And so in the comparison process, it is if it's not eliminated at the stereo microscope, it's transferred to a comparison microscope, which is where light is transmitted through the hair samples on two microscopes. The two microscopes are hooked together with an optic bridge so that you can view the internal characteristics side by side. And at the end of that process, if following the examination of the hair from the entire length of the hair, if that question hair falls within the range of the known sample, we can conclude that that hair is associated with or could have originated from that person. If it fails in that examination at any stage, it would be eliminated as potentially originating from that person.
As it relates to this particular case and the murder of Miss Tara Baker, were you asked to conduct certain hair analyses as part of your work at the GBI in this case?
Yes, in 2001, I was employed by the GBI laboratory and performed examinations on the Tara Baker case.
Okay. And so what I'm going to do at this time, Your Honor, I'll show Mr. Cruz what I'm going to hand to the witness, but I'm going to hand the witness some exhibits that have already been admitted into evidence. All right, Mr. Peterson, I'm going to hand you this little box lid that's full of some slides as well as some envelopes. Starting with the envelopes, do you mind going through those and taking a look at them?
Yes, sir.
All right. And so do you recognize those envelopes?
Yeah, these are samples submitted to the laboratory for analysis. They all contained a unique case number for the laboratory, 2001-1002454, and that was the case number associated to the Tara Baker case.
And what are the exhibit numbers on those envelopes?
We have defense exhibit, I believe that's 17, 16, and 11.
Okay. And let me ask you this. We talked about the process that the GBI lab goes through when hair analysis is being conducted. Is it the typical process of the GBI Crime Lab after a hair that's being analyzed has been mounted to remove it from its mounting, put it back in the envelope, and send it back to the law enforcement agency? Or is it the typical practice for it to remain on the mounting that it was placed on for analysis purposes?
Right. No, it would be left on the slide that it was removed to, and that would become its permanent status at that point.
Okay. As to those envelopes that I've handed to you, are they sealed or are they open?
They appear that they have been cut open from one end.
Okay. Do you see anything on those envelopes that would help you recognize whether or not you had ever interacted with those envelopes?
Well, yes, each envelope, in addition to the laboratory number, has my initials on the envelopes.
And what I'd like to do is retrieve those from you now, and Judge, I'd ask to publish them on the Elmo.
All right, ready?
And I'm going to start with State's Exhibit, or I'm sorry, Defense Exhibit 11. And I just want to point to one part of this. What is that my finger is next to there?
That's the initials that I use on evidence.
Okay. And Defense Exhibit 16. We're going to flip it around the other way, sorry. What's that I'm pointing to?
Also my initials.
And lastly, Defense Exhibit 17. And right there, what am I pointing to there?
Yes, my initials.
The hairs you received I think you already indicated those would be mounted. When they are mounted on a slide and then maintained in that medium, I want you to review now the slides that are in front of you and let me know when you've had a chance to look through all of those.
Yes, I believe these are the slides that I had earlier recognized, that these are boxes containing the prepared slides with mounted hairs.
And I'm going to retrieve one other thing, and then I am going to have some questions for you about that. I apologize. Should have retrieved these before I got you on the witness stand. I'm going to show Mr. Cruz what's already been admitted into evidence as State's Exhibits 108, 109, 110, and 111. Good. Thank you. And Mr. Peterson, I'm going to hand you those items now. And I'm going to ask you the same question that I asked you about the 3 envelopes. Do you recognize those bags, is what I'll refer to them as?
Yes, sir.
And how are you able to recognize them?
Well, each of these exhibits contains the laboratory unique case number, 2001-1002454, as well as my initials on each item.
Okay. And did those appear to be in substantially the same condition as when you received them from Athens Clarke County Police Department?
Yes, there may be some additional seals, but the container itself is the same.
Okay. All right. Now, going forward to the slides in that box in front of you, you had a chance to review those. Do you mind telling the jury what exhibit numbers you are looking at?
Well, I may not say these in order, but I will just go down through the list of the boxes. So I have States Exhibit 124, 122, 125, 114, 117, 118, 121, 123, 119, 120, 116, 115, as well as Defense Exhibit 31.
All right. Thank you, sir. And I think, did you previously testify that these include the slides that you conducted your analysis on?
Yes.
Okay. Did you generate any reports in association with the analyses that you conducted?
Yes. I produced several reports.
I'm going to hand you first what I've marked as State's Exhibit 136 after I show it to defense counsel. And I'll actually go ahead and hand you State's Exhibit 137 as well. And Mr. Peterson, looking at State's Exhibit 136 first, do you recognize what that is?
Yes, sir. This is an official report issued by the laboratory that shows the results of my examinations.
And what date is that report from?
February 2nd of 2001.
And does it appear to be a true and accurate copy of your report associated with your analysis on that date?
Yes.
And Judge, I move to tender 136 at this time.
Any objection? It is admitted.
All right. So looking at 136, does it have certain numbers associated with items that you received?
That's correct. So when evidence is submitted to the laboratory, it's given an exhibit number in addition to a case number.
Okay. And so those numbers that we're about to refer to, those would be, by your terminology, an exhibit number. Is that correct?
Correct.
Okay. Was there an exhibit number 2?
Exhibit 2 is a sexual assault kit identified as that from Tara Baker.
And as it relates, was there an exhibit number 8?
Yes, Exhibit 8 is identified as question hair recovered from the buttocks of the victim, Tara Baker.
And was there an exhibit number 9?
Number 9 was an item identified as question hair from the torso of the victim, Tara Baker.
And then where did exhibit number 10 come from?
10 is identified as question hair recovered from the left hand of Tara Baker.
It also, as part of this submission for your analysis, were you given known hair samples from any individuals?
Yes, that shows 5 known hair samples that were submitted on that same date.
And starting with Exhibit 21, whose hair sample was that?
Known head hair of Chris Melton.
And Exhibit number 22?
Known head hair of Christopher Hall.
And Exhibit number 23?
Known hair of Jeff Hall.
And Exhibit number 24?
Hair sample of Ashley Peavy.
And then Exhibit number 25?
The hair sample of Valerie Lang.
Okay. And as part of that sexual assault sexual assault evidence collection kit of Miss Baker, would there have been known head hairs as part of that kit?
Yes.
Okay. So now we got the known head hairs of Tara Baker, Chris Melton, Christopher Hall, Jeff Hall, Ashley Peavy, and Valerie Lang. Is that correct?
That's correct.
Okay. And then as far as hairs for which you are being asked to do a comparison analysis to see if there are any associations, you have a package identified as containing hair collected from the buttocks of the victim. You have package containing hair collected from the torso of the victim. And then you have a package containing the hair from the left hand of the victim. Is that correct?
That's correct.
Okay. I want to start with the comparison between the known samples in Exhibits 2 and 21 through 25 against the hair collected in Exhibit 8 from the buttocks of Miss Baker. Did you perform an analysis related to that?
I did.
Okay. And what, if any, opinion do you have based upon your findings as it relates to Exhibit 8?
Exhibit 8 revealed that there was one head hair microscopically consistent with the known hair of the victim, Tara Baker. There were 2 hairs inconsistent with the known hair of Ms. Tara Baker, and subsequent comparisons showed that they were consistent with the known hair of Ashley Peavy.
And so let's talk about consistent with the known hairs of an individual. what does that mean?
It means basically that they had a correspondence in their microscopic characteristics that in comparing the question hair to the known hair, they possessed sufficient similar characteristics to they could be included as a possible donor of the hair, that either would be from that person or another person possessing hair with the same characteristics.
Okay. And so as it relates then to Exhibit 8, and please correct me if I misstate anything about your findings, of the 3 hairs that were of a quality that could be analyzed, 1 was consistent with Ms. Baker and 2 were consistent with Ms. Peavy. Is that correct?
That is correct.
Okay. I want to go forward to Exhibit 9, which is collected from the torso of the victim. As it relates to your analysis on Exhibit 9, what opinion were you able to develop based on your analysis?
Exhibit 9 indicates that there were numerous head hairs consistent with the known hair of Tara Baker, the victim. 1 head hair inconsistent with the known head hair of the victim. And then further microscopic examination of that particular hair against the known hair of Valerie Lang showed them to be consistent.
So the hairs that were analyzed there were some that were consistent with Ms. Baker, the victim, and then the one that was not consistent with Ms. Baker was consistent with Ms. Lang. Is that correct?
That is correct.
Okay. And so as it relates to the hairs that were found to be consistent with Ms. Hall and Ms. Lang that were recovered from Ms. Baker's body, those were also compared against Mr. Melton, weren't they?
Yes.
Okay. And what was your finding regarding those hairs as it related to Mr. Melton?
Well, the hair was eliminated as potentially originating from him.
Okay. So as it relates to items 8 and 9, those hairs could not have come from Mr. Melton. Is that right?
That's correct.
Okay. And now I want to get to Exhibit 10, which is the hair from the left hand of Miss Baker. Based on your analysis of that hair, what opinion did you form regarding that hair?
The hairs identified from the left hand of Tara Baker, there were several head hairs and 1 pubic hair, all of which had the similar characteristics as Miss Baker's own hair.
So they were consistent with Miss Baker's hair, is that correct?
Correct.
And so that head hair, or I'm sorry, not head hair, that hair that was recovered from Miss Baker's left hand, was it compared with Mr. Melton as well?
Well, the head hair would have, yes.
Yes, and so that head hair that was compared with Mr. Melton, what opinion did you form as to whether or not that head hair could have come from Mr. Melton?
He was eliminated.
Okay, and what does eliminated mean?
Did not have corresponding microscopic characteristics.
Okay. As it relates, sir, to Exhibit 137, states 137, do you mind telling me what that is?
Again, this is an official report which I produced under the same case number 2001-1002454, the case number for Tara Baker, issued on February 27th of 2001.
And is that appear to be a fair and accurate copy of the report that you generated based on your analysis on that date?
It is.
And Judge, I move to tender states 137 at this time.
Any objection? No objection. It is admitted.
And as it relates to states Exhibit 137, Mr. Peterson, it makes reference to Exhibit 2 again, is that correct?
It does, yes.
Okay, and Exhibit 2 is the sealed sexual assault evidence collection kit of Miss Baker, is that correct?
That's correct.
Okay, and in there it has listed in Exhibit 12, what is that?
Exhibit 12 is identified as is a power transformer.
Okay. And did you have an opportunity to process that item for any kind of trace evidence?
Yes, hairs were recovered from that item.
All right. And so this power transformer, the hair that you analyzed that was recovered from that, what, if any, opinion did you form?
There were several hairs that were unsuitable for comparison. They did not possess enough characteristics to produce a meaningful comparison. In addition, there was one head hair which was suitable for comparison. And additional examination, comparison of that hair showed it to be consistent with the known hair of Chris Melton.
Okay. And so that's a separate thing than anything that was found on Miss Baker's body, though. Is that correct?
I believe so, yes.
All right. I want to go back now to exhibit number 10 in the hair that was in Miss Baker's hand that was consistent with her and eliminated Chris Melton. Have you had other occasions where you have examined hair that's been found in the hands of a homicide victim?
Yes, I have examined a number of cases, a large number of cases where hairs were recovered from the victim's hands. And the vast majority of time, the hairs were always consistent with the victim's own hair.
Okay. So this finding wasn't an unusual finding then, is that fair to say?
It was not.
Okay. If I could have just a moment, Your Honor. Mr. Peterson, thank you very much. I don't have any other questions for you, sir. I'm sure Mr. Cruz will have some.
Mr. Cruz, cross-examination.
Mr. Peterson, thank you so much for your time. The state asked you about the power transformer and the hair found on the power transformer. Do you remember that?
The notes reflect that it happened. This case happened a long time ago.
Correct. My question is, do you recall the state asking you about a power transformer and hair found on the power transformer?
Well, I mean, we just discussed it. Yeah.
Yes, sir.
Yes.
Okay, excellent. You don't know where that power transformer was located in relation to Ms. Baker's body, do you?
No, I do not.
I'd like to go over some of the hairs and the examinations you conducted. Is that okay?
Okay.
And I'd like to establish something first. So would you agree that Caucasian hair is different from African American hair?
I would agree.
Okay. And would you agree that based on your profession and expertise, it is easy, Caucasian hair is easily distinguishable from African American hair? Is that fair?
The vast majority of times, yes.
You examined a hair from the buttocks of Miss Baker. Do you recall discussing that?
Yes.
That hair was not consistent with African American hair. Is that correct?
That's correct.
You examined a hair from the torso of Miss Baker. Is that correct?
That's correct.
That hair was also not consistent with African American hair. Is that correct?
That is correct.
You examined hair from Miss Baker's left hand as well. Is that correct?
That's correct.
And you would agree that hair was also not consistent with African American hair. Is that correct?
I agree.
We discussed the power transformer, but you examined hair from the power transformer. Is that correct?
Correct.
Okay, and the hair on the power transformer was also not consistent with African American hair. Is that right?
That's correct.
And I believe you testified that the hair found on the power transformer was consistent with Chris Melton's head hair. Is that right?
That's correct.
You even examined a hair found on Ms. Baker's wallet. Do you recall that?
There was a hair identified as from the victim's purse, I believe.
From her purse?
It's identified as a purse.
Okay. And that was a pubic hair. Is that right?
No, I believe that was a head hair.
Okay. Your Honor, I would move to introduce Mr. Peterson's course indulgence.
And, Your Honor, I would have an objection. I don't believe that the items that Mr. Cruz is asking this witness about have been tendered into evidence by either party. So I think that would be required prior to questioning the witness about the items.
Go ahead, sir. Yes.
Well, I disagree with that, Your Honor. I asked him a question about testing that he's conducted. The testing is within this witness's personal knowledge. He has gave a statement that is inconsistent with the report that he's written, and I'm introducing this report as a prior inconsistent statement.
All right. Let me see counsel at the bench for a minute, please. Thank you. Thank you. All right, ladies and gentlemen, I'm going to give you all your lunch break now. And so it has arrived. So if you'll go into the jury room and we'll present it to you, we're going to be back on the record in 40 minutes. And please don't discuss the case. We'll see you at 1 o'clock. Thank you. Court is in recess till 1 o'clock. Thank you. You'll have a seat, Mr. Peterson. Thank you. And we'll go back on the record. All right. So there was some discussion at the bench about Mr. Cruz wanting to use a document to examine this witness under 24-6-613. The state asked, pursuant to that statute, certainly, to get a copy of what you were using. And then the state made an argument pursuant to 603. I mean, I'm sorry, to 403. And so because of the state's argument about 403, the balancing test, I wanted to go through this moment outside the presence of the jury before I make a ruling. And so, Mr. Cruz, I'm going to let you examine this witness with that moment. And the law requires that you allow the witness to, I'll just use this language of the statute. The witness is first afforded an opportunity to explain or deny the prior inconsistent statement, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement or the interests of justice otherwise require. So before I get to that portion of the statute, I want to hear what we're talking about because the state has made a 403 objection. So you may proceed, Mr. Cruz. With the question you were going to ask him. He answered a question, and you wanted to attempt to impeach him with a prior inconsistent statement. The state objected based on 403 grounds, and so that's why I'm conducting this hearing outside the presence of the jury.
Excellent. So just to let you know the process that was taking place when the objection was lodged, I was about to mark this as defense exhibit, I believe, 32.
You asking if I have it, defense exhibit 32?
Oh, no, sir. I was asking.
Not yet.
Well, I'm sorry.
Not yet.
Okay. So I was going to mark this
Okay.
as defense exhibit 32.
Okay.
And my next question to him after I marked this as defense exhibit 32 was going to be in your March 19, 2001.
Well, actually, before we even get to that, Mr. Cruz, you may not need to get to that moment. Let me ask you this question. Let me ask counsel. Now that you're going to mark it as an exhibit, it kind of takes a different turn.
That's where the objection
Okay.
came.
Okay. So, well, it did because you weren't tendering it, and you don't necessarily have to when you're dealing with a prior inconsistent statement.
I actually was going to admit the prior inconsistent statement into
Okay.
evidence, but I typically mark it for purposes of the record.
Okay. Well, that's fine. Well, let me ask this question of the state first. Based on that he is going to offer it into evidence, do you have any objection? Do you have any objection to that? I mean, based on the conversation counsel had with the court at the bench, the reason I'm doing this outside the presence of the jury is because of the 403 argument. So is there any objection to the tendering of that document? Is there going to be?
I'm sorry, Judge.
Is there going to be any objection to the tendering of that document?
I think that there would be as it relates to examination regarding a hair found in a wallet. And the reason is, Judge, and I would, if the court allows me under 24-1-104, I think this would be a matter of a preliminary question. And I can state in my place that pursuant to documents that are in discovery and produced to Mr. Cruz, this item actually didn't come into, the item was not believed to contain any hair at the time of the initial processing of the crime scene. It was returned to the Baker family, who then, over 2 weeks later, on February 8th of 2001, brought the wallet back to Athens Clarke County Police Department and relinquished custody to the Athens Clarke County Police Department. And then subsequently, in a transcript of an interview between ACCPD and the Baker family in May, Miss Baker's father, Mr. Lindsay Baker, stepfather, but the person she considered to be her father, Mr. Lindsay Baker, indicated to police that we found a hair in that wallet. What have y'all done with it? And so I imagine what Mr. Cruz is going to question the witness about is whether or not that hair was tested. And so I guess our objection under 403, our objection pursuant to 24-1-104 is there's been a lot of discussion about chain of custody as it relates. Now, in this particular circumstance, I think there is a legitimate concern about chain of custody and the manner in which it came into the possession of law enforcement and the GBI, which is why additional testing was not done. If testing had been done, it still probably wouldn't be admissible in a legal proceeding, due to the fact that it came from a wallet that had left the crime scene and been in the possession of other parties for, fairly extended period of time. We're not talking about an hour or something like that. So.
Okay. All right, thank you. Mr. Cruz, do you want to respond to that? And then I'll let you ask the question. I may have some questions for you. Do you want to respond to that?
I just want to make sure I understand the objection was to 403, but also chain of custody. Am I understanding that correctly?
Well, I'm not going to put words in Mr. Yalamanchili's mouth. I can tell you what the court thinks it is, but go ahead.
Foundation for admissibility of the evidence that he is questioning the witness about. I think if we are going to talk about evidence, it needs to be present and tendered in the courtroom. Now, it could be that Mr. Cruz goes through the process of tendering that evidence in some manner. It just hasn't been done yet. So, I mean, I guess my objection's on a couple of different grounds.
All right.
Yeah.
Go ahead.
So I understand foundation is a ground, chain of custody is a ground, and 403 is a ground. If I could ask clarification from the Honorable Court or Mr. Yalamanchili, as far as 403, what particular ground do I need to address?
You can ask the state.
Well, Your Honor, when we were at the bench, I think my original objection was actually to the predicate requirements of a prior inconsistent statement not having been met, because I think Mr. Peterson testified that he believed that it had come from a purse, and Mr. Cruz had indicated it had come from a wallet, and we stated at the bench, so it was our belief and our understanding of the evidence, it actually came from a wallet that was inside of a purse, so it wasn't necessarily something inconsistent with Mr. Peterson's testimony.
All right, so in regards to the foundation of a prior inconsistent statement, Mr. Peterson, I asked him, was it a pubic hair? He said it was a head hair. I asked him, was it on a wallet? He said it was in a purse. It's semantics, but my particular question asked about a wallet. His report references a wallet. It's not reference a purse. So the foundation has been laid for a prior inconsistent statement. He was confronted with the statement. Well, was about to mark the exhibit to confront him with the statement before the objection came about. But once I've given him an opportunity once I've confronted him with that statement, if he says, no, it's still a head hair, or no, it was in a purse, at that time I would tender this into evidence as impeachment material. In regards to the chain of custody, this isn't a chain of custody issue. Chain of custody applies to fungible evidence, not to documents. So chain of custody would not apply in this situation. In regards to the state's argument, as far as I need to tender the hair in order to impeach Dr. Peterson, in regards to the hair, there is no case, no law that exists that would support that proposition anywhere probably in the United States. And lastly, in regards to 403, Your Honor, I still wasn't 100% clear on the exact ground of 403. So I would ask for the 403, just look, the specific grounds for 403.
Confusion of the issues and misleading the jury.
Okay. In regards to confusion of the issues in this case are whether or not Mr. Faust committed this crime. This evidence is evidence either in support of Mr. Faust committing the crime or evidence that goes against Mr. Faust committing the crime. The anticipated testimony from Mr. Peterson's report is that the hair that was on the wallet was a pubic hair, and it was of Caucasian origin, or the way I asked the question, it was not a African American hair. I had no intentions to ask about testing the hair. I now do, but it's relevant. It won't confuse the issue because it goes directly in line with our theory that Mr. Faust was never in Ms. Baker's home. And this testimony supports that materially, Your Honor.
Okay. Mr. Cruz, let me ask you this question. Well, first, I'm going to let you ask him about a prior inconsistent statement and give him the chance to respond. And then I want to talk to counsel about something else.
Sure.
So you may go, because I don't agree that you've established that you have the right to present evidence about a prior inconsistent statement yet. So if you believe that's going to be the case, I'm going to let you try that.
Sure. May I mark the exhibit, Your Honor?
You can for this particular purpose, but we're having a hearing outside the presence of the jury.
Sure.
So just go ahead and ask him the questions you were going to.
Yes, ma'am. Thank you for your patience, Mr. Peterson. You obviously know where I'm going with this line of questioning, but you examined the hair found on Ms. Baker's wallet. Is that correct?
Yes, I had earlier said purse, just from my recollection, but by looking at the report, it does reflect hair from a wallet.
Okay. And would you agree that it's also a pubic hair?
No.
Mr. Peterson, in your report dated March 19th, 2001, did you state, course of indulgence, I'm mistaken. You are correct. You are correct. Okay.
All right.
So we are clear on the wallet portion, and I was incorrect as far as the pubic hair. Please forgive me.
All right, thank you. So let me just respond then to, well, before I respond, unless Mr. Yalamanchili, since it's your motion, do you have anything else you want to say about your argument about this information under 403?
No, Judge.
Okay. Mr. Cruz, do you want to respond to their argument about this evidence being violative of 403?
The proffer that I gave to the upper court, I would stand by that.
Okay. All right. Thank you. So both parties have given a proffer about what this line of questioning is about. And I will say this. I agree with the state that this is violative of 403.
Yes, ma'am.
Because of the proffer that the state has made about the circumstances surrounding the testing of this purse, wallet, several weeks later, under the circumstances that they have described, is a moment, I would say, of profound confusion, possibilities for the jury. And so I'm going to grant the state's motion with regard to the concern about 403, and I'm going to instruct you not to go into that area of questioning with regard to the testing of this purse, wallet, this line of questioning. I'm going to instruct you not to go down that line of questioning.
But don't touch on the wallet to make sure.
That's correct.
Yes, ma'am.
All right, thank you. All right, I'm going to bring the jury in because I want everybody to be mindful. It is 1:20, and we are supposed to be ending at 2:30 today. As best we can, there's a juror that's going out of town. This may be our last witness, but I just want everybody to remember, we're running behind. It's 1:20. So, all right, anything else? You ready for the jury to come back in, Ms. Cruz?
Yes, ma'am.
All right, state ready?
Yes, Judge.
All right, if you'll bring the jury in. Thank you. You all may be seated. Mr. Cruz, your witness.
Thank you. Mr. Peterson, you would agree that there was pubic hair found in Ms. Baker's left hand?
Correct.
And that pubic hair was tested against the known sample of Mr. Melton's head hair. Is that correct?
No, that would only be compared against pubic hair.
So it's compared against Mr. Melton's pubic hair?
Yes. I believe that's correct.
All right, in your report, did you write microscopical examination and comparison of the questioned hair removed from items? I want to ask you this before I even ask you that sentence. Item 10, we can agree, is the hair from Ms. Baker's left hand.
That's correct.
Okay. And in your report, you wrote microscopical examination and comparison of the questioned hair removed from item 10 with the known head hair of item 21, 22, and 23 reveals they have dissimilar microscopic characteristics and therefore could not have originated from the same source. Is that fair?
Yes.
Okay. And item 21 is listed as the head hair of Chris Melton. Is that correct?
Correct.
Okay. And I believe on director testimony was that hairs that grow in different areas have different characteristics. Is that correct?
Yes.
Okay. Can you show me the report where you tested item number 10 against Chris Melton's pubic hair?
Don't believe that's in the February 2nd report. I think that's in a subsequent report.
Sure. Can you show me?
I wish you would show me.
Sure. And was seeing all of your reports refresh your recollection?
Well, I have two reports, State's Exhibits 136 and 137.
Well, Mr. Peterson, you just asked me you wish that I would show you. I'm willing to show you. Would reviewing your reports refresh your recollection?
Yes.
Okay. I am going to show you your, or let the record reflect that I'm showing you your report from March 19th, 2001, May 16th, 2001, October 11th, 2001, February 2nd, 2001, February 27th, 2001, and that's two reports, two separate reports, and March 19th, 2001. If you will take a look at these documents to refresh your recollection and let us know once your recollection is refreshed. May I approach? And just so there isn't any confusion, to make the record clear, I am asking about the pubic hair found in her left hand being tested against Mr. Melton's pubic hair.
Well, if that hair from the hand, which was eliminated microscopically, the victim's own hair, if there had been another pubic hair sample submitted, then it would have been identified as also being consistent.
The answer to my question, my question is, was the pubic hair found in Ms. Baker's left hand tested against Chris Melton's pubic hair?
Well, the characteristics of his hair are dissimilar than those of Tara Baker's hair.
Please.
Are you asking me that there should have been a recorded statement saying that the hair was eliminated, as opposed to my testimony today that it is not similar to Tara Baker's pubic hair and therefore could not have been his?
The question I'm asking is whether the pubic hair found in Ms. Baker's left hand was tested against Mr. Melton's pubic hair. And if you can, yes or no?
It was not similar to the pubic hair from her left hand.
That doesn't answer
Eliminated.
my question is, and maybe I'm saying that wrong, please forgive me. And if you can answer yes or no for me, please do so. You had Mr. Melton's pubic hair, is that correct?
Yes.
Okay, and pubic hair was found in Ms. Baker's left hand, is that correct?
Yes.
Okay. Was that pubic hair of Mr. Melton's ever tested to see if it was the pubic hair in Ms. Baker's left hand?
It was indirectly eliminated because a comparison of the knowns also took place to know what their characteristics are, and they were not found to be similar, so it could not have been consistent with the hair from the left hand.
Is that a no?
Sorry?
Is that a no? Is
No,
the
it's
answer to
not
my
a no.
question a no?
The comparison does not have to be a direct comparison. The characteristics of the two known samples are not the same, so they both can't be consistent with the hair that's only consistent with hers from the left hand.
And I thank you for that information. That is great information, but I'm asking you a specific question. To my question, is that a yes or a no? Was it tested?
Yes.
Can you show us the report?
No.
Okay. No more questions, Your Honor.
Any redirect, Mr. Yalamanchili?
No, Judge.
All right, may this witness be excused?
Yes, we ask that he is.
Any objection from the defense?
No, ma'am.
You are free to go, sir. You may call your next witness.
Your Honor, could we approach?
You may. We have an hour. Yes, sir. All right, ladies and gentlemen, believe it or not, we have finished early today. So, particularly the person going out of town, yay. All right, so I'm going to release all of you today, obviously at 1:30, and ask you to return again on Monday at 9 o'clock. Obviously, in the meantime, my instructions continue to apply. Please don't discuss the case with anyone. Don't do any independent research. Don't look on social media with regard to this case, if it is on there, or the news, if it is on there, all the things that we've discussed. Does anybody have any questions for the court? Don't go to any locations that have been discussed, of course, by any testimony. Anybody have any questions for the court before I release all of you? I appreciate your patience this week. It has been a productive week in terms of a lot of things we've gotten through. I appreciate your patience. I know you go in and out of the jury room a lot. That's certainly common in a trial, but I know that it is sometimes, it could be aggravating for you to get up and get down and get up and get down. I know that. So I appreciate your patience with that. Next week, we're going to hopefully have more of an opportunity to have a normal lunch break. Like I said earlier, you can go outside and stretch your legs and things of that nature. We'll have to see how the timing goes, but that would be my plan. So with the thanks of the court, you're all free to go, and we'll see you Monday morning, 9 o'clock. Thank you. In this courtroom.